Now we're going to go to the Association for Reform Political Action. Mr. Schutten.
All right, thank you very much, and good evening, honourable members. My name is André Schutten. I'm a lawyer with ARPA Canada. We were interveners in the Carter case, and we have analysed the various legislative and policy proposals that have been published since that decision was released in February by the Supreme Court. I want to emphasize at the beginning that Parliament is not forced to pass a law legalizing euthanasia or assisted suicide. If Parliament passes such a law, it does so willingly and cannot wash its hands simply because the Supreme Court made you do it. In fact, the Supreme Court made an error, and Parliament has a moral duty to correct that mistake. Parliament has a legal option, and I'm not talking about the notwithstanding clause. They have a legal option to fully protect all human life by prohibiting euthanasia and assisted suicide, and I'm happy to discuss during the question period how that can be done as an amendment to C-14. If Parliament insists on choosing to legalize assisted suicide and euthanasia, it will put the lives of vulnerable people at unacceptable risk, thus violating their constitutional right to equal protection of the law. The Supreme Court Law Review just published an article I wrote making that very argument, and again, during the question period, I'd be happy to take questions on how C-14 and the Carter decision actually violate the constitutional rights, Section 15 constitutional rights of men like James and Pieter sitting beside me. Now, I'm a healthy, able-bodied Canadian, as are all of you, and including the doctor who you just heard from. But I don't think we fully appreciate the disadvantage that C-14 puts on some of our fellow Canadians who courageously face many obstacles we will never face. So instead of me trying to convince you of those types of things, I've asked two such Canadians to share their perspective directly with you, to comment on how C-14 affects them, and then to share changes that they believe are necessary in order to make them feel just a little bit more secure living in a post-Carter Canada. So I'm going to turn it over to James first, and then to Pieter.
Hi, I'm James Schutten. Thanks for the opportunity to speak to you about this important issue. When I was 2 years old, I was diagnosed with spinal muscular atrophy, which has left me with serious physical disabilities. I require someone to set up my feeding tube, suction my trach, turn me over in bed, take me to the bathroom, and scratch my head. I'm not telling you this to make you feel sorry for me. I don't feel sorry for myself. But you need to know that these professionals and family members need to care about my life and whether I live or die. This is why I needed to talk to you about your draft law legalizing doctor-assisted death and how that law will affect me and others like me. I've gone to the hospital because of illness, and medical staff questioned whether extreme measures were worth it. This makes me very nervous because I feel like I'm not worth the trouble. Thankfully, my family has my back to speak with the doctors on my behalf. If I have anxiety now, how much more if Bill C-14 comes into effect? What if society started from the perspective that I do have value? What if people didn't view me as a burden for others to carry? I am one of those people who the Supreme Court of Canada thinks should have this right to doctor-assisted death. But what if, instead, I had the right to palliative care or resources to help me continue to be a productive member of society? I believe others like me feel the same way. But with this right to die, it makes me feel like society thinks I should choose to die. Therefore, I urge you to add to Section 241.2, Sub 3, the requirement that palliative care is meaningfully made available to the patient. Look past my wheelchair and see that I am an asset in my community. I volunteer at a nursing home a few days a week and help out at an elementary school. all of which I really enjoy. I don't believe that anyone has the right to choose exactly when to die, but God alone decides, and he does not make mistakes. He has a purpose for everything. My faith and family add value to my life. Instead of investing money into a bill which normalizes the choice of death, our country should invest time and money into giving people with illness, disabilities, and old age a will to live. I have one last thing to say. I want you to know that I am not a public speaker. I was very nervous to come here, but I feel that this goes far beyond just me and my insecurities and limitations. I need to speak up because this is so important. Please remember me when you make your decision. Thank you.
All right. I'd like to echo, first of all, a thank you to you all for allowing me to come here and the privilege to speak to you, members of the committee. And also to echo James's concerns and to add my own 2 cents. As I do have concerns with Bill C-14, including its lack of precision in language. Sadly, I feel that the bill is dangerously dependent on euphemisms. Throughout, medically assisted dying is used to describe what is in reality physician-assisted suicide. This is problematic in the way that it undercuts palliative care. After all, what is palliative care if it is not medically assisted dying? I urge you to please use accurate terminology so that termination of life is not confused with palliative medicine. Furthermore, the proposed law necessitates that in order for someone to assist an individual with suicide, a medical professional must be of the opinion that the person meets all the criteria, including the opinion that they have a grievous medical condition. Since the term grievous is vague, an attempt is made to make that definition more specific in section 241.2 sub 2. However, even here, Bill C-14 runs into problems. How is one to define intolerable suffering as opposed to tolerable suffering? The reality is that intolerable suffering is relative. Suffering is modified by many diverse factors, and therapies and treatments are readily available to address all of these factors. And not only is unendurable suffering relative, but it is too much to ask a physician to judge whether or not someone is indeed experiencing intolerable suffering. In order to ensure that physicians don't approve euthanasia for vulnerable persons like James and myself in moments of weakness, specifics must be added to section 241.2, such as including the need for reasonable proof rather than mere opinion in 241.2 sub 3a, and the addition of a specific prognosis in 241.2 sub 2d to replace the phrase their natural death has become reasonably foreseeable. Section 241 sub 5 provides an exemption for aiding an individual to self-administer a substance with the purpose of ending their life. In an attempt to respect autonomy, the key checks and balances put in place elsewhere in the bill are hereby bypassed. We cannot just assume that people will be protected by the safeguards outlined in section 241.2 sub 3. Most importantly, there must be oversight to ensure that patients are given the opportunity to revoke their request as outlined in 241.2 sub 3h. We must be careful that the appropriate balance mentioned in the preamble to the bill is not skewed too far towards autonomy at the expense of vulnerable persons in need of protection, such as James and I. The only true protection of the sanctity of life is a ban on euthanasia, but barring that, these recommendations will improve the situation for the disabled and ill. Thank you.
Thank you very much, and Mr. Schutten and Mr. Harsevoort, I just want to tell you how much we all appreciate you making the effort to come here today. Your testimony was very, very touching and meaningful, and we will all take it into advisement and very much appreciate it.